So today we're very excited to have the two candidates for Branch 43 in Milwaukee County Circuit Court, which is an open seat following the retirement of Judge Marshall Murray after many years of good service to the county. So we have Marisabel Cabrera and Rochelle Johnson-Bent, and they're both going to be giving short presentations, and then we'll open up for questions. We're just going to ask each candidate to just do 5-10 minutes, and then about qualifications, why they're running, etc. And there's been a coin flip. The suspense was very exciting. And Rochelle won, so she'll go first. Thanks very much.
I'm going to try to stay in the video camera frame, but I'm also going to try to stand up so that you all can hear me. Can everyone hear me in the back? Okay. So my name is Rochelle Johnson-Bent, and I'm running for Branch 43 Milwaukee Circuit Court Judge. A little bit about myself. I am born and raised here in Milwaukee. I was a graduate from Whitefish Bay. I went to North Carolina A&T for undergrad, and then I went to UW for law school. I'm a proud mama of two very talented, beautiful children. I'm also a fur mama to a rescue, Miles Morales, who's just turned 1 year old, beautiful dog. And I also serve as respite care for 4 of my cousins who are part of the foster system. So I help them when the foster family needs some time or need to go somewhere. I'll let them come stay with me, and then we'll hang out as family. And plus, when we need like a holiday coming up, I spend time with them as well. So a little bit about my background. I've been practicing about 13 and a half years. I practiced in areas of criminal, family, civil. I've worked in nonprofit, I worked in private practice, and I currently do government work where I work at Milwaukee Public Schools doing workers' comp. I'm the manager over workers' comp, risk management, and the procurement team. So that's your general liability, that's your risk management, that's your contracts, and your civil cases. As I stated before, I worked in nonprofits. I was a supervising attorney for Legal Aid Society, where I worked. I was the supervising attorney for the Family Court Division, where we are appointed for family cases that involve indigent families. A lot of times those are families who are pro se, so I've worked with a lot of different kind of clientele. So currently I'm working with businesses, your Fortune 500s, small businesses. I've also worked with clientele with different education backgrounds, a lot of pro se litigants, whether I was representing one party and then the other side was pro se, or like I said, as a guardian ad litem. I also represented the minor children where both sides were pro se. I've worked with families with different language backgrounds, so that I have this different variety of clientele that I have worked with. In addition to that, as it relates to my background, I have worked with the court system in different ways. I worked in Milwaukee County predominantly, but I also have worked in other southeastern Wisconsin counties. So I got a chance to see how other courts do things, which is really nice because sometimes you can see what works in another county and what doesn't work in another county. As it relates to my philosophy, as it relates to what a judge is to me, a judge is someone to me, effective judge, is someone not only interprets the law, but someone who can articulate and communicate the law, be relatable and understanding and compassionate to the litigants and the people coming into their courtroom, but then also be able to do that and being firm, being impartial, but also not becoming detached from the community. The reason why I'm running for Milwaukee Circuit Court Judge is for 3 main reasons. One, I come with experience, like I said, with litigation. I've done trials. I've had bench trials. I've had a trial in criminal court. I've appeared in front of a number of the judges in Milwaukee County. I'm connected with and know a lot of the judges, so that's mentorship and knowing the people and what they see and what works for judges, and that helps with the training process. And like I said before, because I've had so many different areas of law that I have practiced in, it makes in the disciplines that I know, it makes when I come on the bench a little bit easier on the learning curve, whether it be in criminal court, family, children's court, because I've worked in all these different areas. The second reason why I will be a good judge is because I believe in the equities of justice, right? So what does that mean? Most of you are lawyers or work with the court system. You all understand what that means in a general sense. But to me, that means being compassionate, being someone who wants the parties to be participants in the system. So when I'm talking to litigants or when I'm working as an attorney on a case, for me, I want to make sure everyone understands what happened. So as a judge, that's what I want. I want to be able to take that articulation and communication and make sure that everyone who walks out the courtroom understands the process. Because if you're not doing that, then you're not participants. And I want to make sure that I'm extending that arms of justice. And then also, I want to make sure that I'm staying connected to the community. So that brings me to my third point, that I am very connected to the community and I care and work with the community. So that brings compassion. So the reason why I say that and why that's important is because I'm involved in a lot of things. So I care about what my kids, when they grow up, the community that they're going to raise their kids in. I care about my friends and family, right? So I want to make sure that I'm staying connected to the issues of our community. I'm involved with the Wisconsin State Bar. I serve as vice president for Highland Community School Board. I currently serve as on the board member on WIS staff. I also have involvement with another community, my sorority, Alpha Kappa Alpha Sorority Incorporated. I go to community brainstorming meetings, the Wisconsin DIMS meeting. I try to stay involved and connected to the community, so I'm constantly educated on the issues that our community are dealing with. Not to mention being connected to some of the experts and resources in our community, whether it be sitting down with people involved in public housing organizations or homeless issues, poverty issues. I like to continue those communications, and I do that now, and I will continue that on the bench. And the reason why that's important, again, when you're connected with the community and you understand the issues of the community, you're more compassionate, you're more thoughtful in how you're making decisions, and you're able to articulate and interpret the law that benefits the people who are coming before you. So those are my three main reasons, like I said: compassion, experience, and equity. I asked that I please give you all, I also brought some flyers if anybody would like, just to remember, because I understand and I know that sometimes you'll hear a name and you're like, I think it was Rochelle, but I bring this so everybody can remember my name. My name is Rochelle Johnson Ben. I hope I gained your support to vote for me on April 2nd for Branch 43. Thank you.
Well, I am Marisabel Cabrera. Thank you all for inviting me here today. I just wanted to give you a brief background on myself. I was born and raised here in Milwaukee of Puerto Rican parents. I'm the first generation to be born outside the island. And I grew up in a family where our core values were very much about education. My family, we grew up in very meager circumstances, and it's something that my parents always instilled in me, that if you wanted to ever come out of poverty and have a higher quality of life and not have to be essentially living paycheck to paycheck, that you need to make sure you got a good quality education. And so for me, I went to middle school on the north side at Edison Middle School. I went to high school at Nathan Hale High School. I went to undergrad at UW-Madison, and then law school I went to Michigan State University College of Law. So I am one of the few attorneys in Wisconsin that did have to take the bar exam to get licensed. And so I am also licensed in Florida, because when I graduated from law school at that time, my parents resided in Puerto Rico, and so that was Florida was as close as I could get to Puerto Rico without actually moving there. Of course, a few months later, they decided to move back to Wisconsin. So eventually, I did come back to Wisconsin and took the bar exam. I started my first job as an attorney at Centro Legal, which is a nonprofit organization that serves low-income individuals that whose income is low, but is just not low enough to qualify for a public defender. And so they still can't afford private counsel. Their Centro Legal provides legal services for misdemeanor cases and family law cases at a sliding fee scale. So that was something that for me, I wanted to serve my community. Even though in law school I concentrated actually in corporate law, I wanted to do mergers and acquisitions, but once I returned to Milwaukee and saw the needs of my community, it was something that was important to me, because again, one of the core values of my family is that if you're ever lucky enough to make it out of poverty, then it is your obligation and duty to help your community members, your neighbors, and to do the same. And so for me, that meant public service. And so I started doing immigration law because many of the clients who I served at Centro Legal oftentimes would ask, how is this case going to impact my immigration status? Or is this going to prevent me from being able to become a citizen in the future? And at that time, my answer was always, that's a really good question. You should consult an immigration lawyer. I'm here to keep you out of jail. So because that question kept coming up so much, I started doing on my own some research around Milwaukee, calling around to see how many immigration attorneys were there, which ones were there. And at that particular moment in time, there were very few. There was about 11, and many of them worked at these big law firms whose clientele mostly focused on universities, hospitals, big engineering firms, and not so much like the more family-based deportation defense cases. And even the ones that I found that did do that, they were not bilingual, they did not speak Spanish, and many of the folk that I came into contact with were Spanish speakers. And so that was something that then I decided to open up my own law practice to fill in that niche, which I learned very quickly that immigration law is extremely complicated and constantly changing. And so that's something that was very different from criminal law, where we have these set precedents that we can rely on. And on the immigration side, that doesn't really happen. And so you always have to constantly verify whether something is still current law. And for me, immigration law, I started seeing through that area that it doesn't just stay in one box of immigration law. It overlaps with so many other areas of law, which is what led me to children's court, traffic court, family law court, all these different courts, because even like the Bureau of Milwaukee Child Welfare, for instance, they contracted me several times to assist with children that were in their care who had immigration issues. So then I had to go to the children's court to get court orders to allow me to process them and get them their green cards. And I will admit that those cases are definitely very, very difficult because it's not just the immigration issues that you're handling. You have to also keep going back and forth with the state courts, which the immigration agencies and courts really will not press pause for anything else happening outside of the immigration arena. So that was something that for me, with my criminal defense background too, it really helped me with serving a lot of clients whose criminal attorneys did not know how to represent them in immigration court. So with that background, I was able to assist many people either become eligible for immigration benefits or have a defense and deportation proceedings. So for me, running for this position isn't just about being a judge. It's about carrying forward all of the experience that I've gathered within the last several years. I've been practicing law for nearly 18 years now. I became involved in politics because I have a deep commitment to public service, and I wanted to, every position I've held in the past has always been with an eye towards serving my community and using my skill set and knowledge and experience in any way that I can to help benefit my community. So this is another opportunity where I see I can serve in a different capacity. I've served on the Fire and Police Commission for 6 years, which gives me another sort of unique experience in that many of the cases that we saw there for disciplinary proceedings were quasi-judicial cases where we had to hear testimony, review evidence, apply standards, legal standards to those set of facts to determine whether the discipline was called for, and if so, is it the appropriate type of discipline. So that's something that I think is unique for my background, in that I do have experience actually presiding over cases, and I think that's something that's really important to consider for a judge, that you not just have legal experience, but you have experience presiding over cases. And so to sum it up, really the three reasons why I'm running for this: again, I have a deep commitment to public service. I also want to build and increase the public confidence in our courts. I think that many folks have lost that confidence. We in Wisconsin have, the data shows, very big disparities in our judicial system, and I would like to help with improving those outcomes. And also, I do believe in our system. I just think that it's not operating the way we all hope that it would. And so that's something that I do want to make sure that we have equal and fair proceedings for everybody under the law. Thank you.
Okay, so we can open it up for questions. If folks have questions for the candidates.
I have a question. What is the most difficult decision you have ever had to make, and what informed your decision-making process?
Do you want us to stand or stay seated? Okay. One of my most difficult decisions as a practicing attorney, having been in before becoming an immigration attorney, a criminal defense attorney, was that I had a case where my client really was held in immigration detention, and his family came to ask us for help to get him out of the detention center. And technically, based on the law and his criminal background history, he wasn't eligible for bond. Under immigration law, there's a list of offenses that if you have been convicted of, you are subject to mandatory detention, so you're not even eligible for a bond. But our client's family wanted us to try, and I went forward. And this particular client, before these proceedings, was arrested for battery on a pregnant woman. And it was a very difficult decision for me because he really didn't have much to argue on, because the law already said he's subject to mandatory detention. And the only thing, it was very difficult for me because essentially what we argued was that we blamed the victim, which for me as a criminal defense attorney was, it was difficult because I had already come into contact with many folks through that system, and a lot of times the reason why a case would be dismissed would essentially be because witnesses would not be present. But the other side of that was I do have personal experiences with that sort of domestic violence, and so it was very hard for me to decide this is the only option we have, but I have to defend my client and represent my client to the best of my ability, and this is really the only option we had. So that was very difficult for me. When you're on the defense side, you have to zealously defend your clients, and sometimes, it's still within the bounds of the law to argue things that you don't necessarily personally agree with, but that's what you have to do for your clients. And so for me, again, in the judicial arena, it's going to come up very often where you might be sympathetic to both parties, and you have to make a tough call and just apply the law accordingly.
I would say I have a couple examples that came to mind, but I'm going to give a personal story and then I'll give one in terms of in practice. For me personally, it's because it comes to mind for the most recent issue, is, as I stated earlier, I have 4 cousins who are currently part of the foster care system. And when they were taken out of custody from their parent, it was an emergency situation. They called out to a number of family members, and I was the only one who really had the capabilities to take the kids into my home. So I took them in on a temporary basis as their foster parent, with the conditions that there's a number, I need help, because that's 4 kids, plus I have my 2 kids. That's a lot for a single mom to handle. So when it became the decision, and again, this is my personal story, when it came the decision to let the kids go back into the system, the foster system, to go with a host family that luckily I was able to talk to and kind of get some information on. The reason why it was a difficult choice for me is because when I'm part of the case, right, as a foster parent on it, you get a lot of information. You're part of the proceedings, you're part of the discussions, and so I knew that if I wasn't part of the conversation, I wouldn't know what was going on, and that eliminates a lot of communication that goes to the other family members who need to know what's going on as well. And so, but I had to make a decision, obviously, for the betterment of our family, plus the kids, right? So if I can't give them the best that I can give them, I don't want them just be in my home just for the sake of, oh, all of our kids are together. I wanted to make sure that they were going to go in a good home. So it meant sitting down with the guardian ad litem and having that conversation with her as to why I was making the decision that, yeah, it's best to go ahead and put them in a different home, but then also talking about what that would look like afterwards and what that communication with the social worker afterwards as relates to communicating with me as to when they're going to move to different homes, or if there's going to be issues and resources they need. And again, using me as that respite care when the kids did need a break or the families needed a break to utilize me. Again, because our system, as you said, is not perfect. A lot of times when you have one party who is more aggressive or knows the system, and then you have other litigants who don't know the process and don't know the system, and then I understand the children's court process, I was able to speak to the state attorney. I was able to speak to the guardian ad litem and give them like, hey, here's the information you need to make this argument. You don't have to just go with what the DA is saying. So I knew that being removed from the situation, I wouldn't be in the crux of the issues. But for me, that was you sometimes got to do what's best. And so to me, I translate that to, as a judicial person, you have to be able to sometimes look at when litigants come into our courtroom, there's circumstances beyond what's just before you, right? They are dealing with so many more things. And to be able to articulate, ask questions that help you understand the picture as the whole picture. So the judge on the case was able to ask more questions to get a better understanding, that made a decision that helped these kids move out to California for a short period of time, to be with their grandmother for a period. So the transition was easier. Had she not done that, because if she didn't ask those questions, didn't get a little bit more involved, didn't just stick to this template, then she wouldn't have known this information. Again, this is a lot of encouragement because I was part of the process. Had that, now that I'm not, I have to, in the background do those things. But that's an example of me having to make a conscious decision and a decision that's best for myself. But in a professional world, I have a case in which the school district had to decide on settling an issue. And sometimes when you have the authority and the power to evaluate wrong or right, I try to always defer to what makes the community better. So we had a case in which the law was on our side. The judge has made it very clear in articulating the issues before him that the law was technically on our side. But there was an injustice here. It was a harm that occurred to a student that deserved to be a wrong, deserved to be right. They deserve something. And even though the law helped us in terms of protections from a significant lawsuit and significant damages, my role as the person who can make a decision on settlement was, do we want to use the law to harm people and make people feel this is how the system works? Or do we want to use the law to help them feel like they got some justice? So what I did was I made an agreement, a settlement with, well, first off, I went to my boss, right? Because we have obligations that way too. So I went to my boss, I explained my position, and I said, this sets the tone. This sets that we're not trying to necessarily harm our just because the law allows us to sit there and tell someone no, or we don't have to do, we have a statutory limitation, or we don't, this didn't fit into that, you don't fit into this qualification, that therefore we don't have to fix it. I said there was a wrong. Let's tell them how we fix this issue. Let's settle and give them something that says that we understand there was some damage done here, and move on. Let the family move on, because I feel like we were tying them up by just using the powers of our system. And I think the court agreed with us. I think the court really was like taken back by our settlement to it and looked back and reflected, and it's like, you know what? This was a really good settlement. This is a good chance to utilize the power of your money, because you're dealing with families. They don't usually have a lot of money. your money, your power, your understanding of the law in helping people right or wrong.
Next question.
Yeah, Ms. Cabrera spoke about, one, the criminal justice system not being viewed well, and we see that manifesting itself, for instance, in the changes to the bail constitutionally, because people get upset about people being out. But on the other hand, she spoke about good outcomes. Let me say that I appreciate, first of all, that both of you have experience beyond the criminal justice system. But I was a public defender, so I'm concerned with the criminal justice system, where to a degree you'll first be serving either in the juvenile system, misdemeanor, or something like that. What do you consider a good outcome, to use that term in generally? How do you measure outcomes? And how do you feel you'll act in the face of a community that might not like outcomes that are coming out of the court? Because people you've served may not trust the courts, but there are sure a lot of people who are vocal and are forcing the courts to make us the worst state in the union for salting people away in prison. So,
Right. So for me, it's interesting because I actually am serving in my third term as a state representative representing the 9th Assembly District. So I was actually on the floor when this bill came forward to send it to the masses to vote on whether we want to amend our Constitution. And one thing that I think a lot of these things come about is that a lot of the legislators don't understand how the law is actually going to be applied in the real world. They kind of go off of what their constituents, yell at them about or, complain about, and so then they want to appear as though they're being responsive, and they come up with these ideas and legislation that, for me as an attorney, I see is not going to be something that is great for our communities, because while yes, we want to, keep dangerous individuals off our streets and keep them from harming others after they're waiting for their current proceedings to move forward. They have only been accused. They haven't actually been convicted, and so our Constitution says that we aren't to deprive people of their life, liberty, or pursuit of happiness without actual convictions. And so this is something, though, that in the legislature they don't seem to really care so much about. I attribute that to being the fact that when I first got there, out of the 132 legislators, 99 state representatives and 33 senators, only 12 were lawyers. And I thought, oh, that explains a lot. Because a lot of times when they would circulate these pieces of legislation for co-sponsorships, I would see it immediately and see, like, this is actually unconstitutional. We can't do this. You might not know this, but let me explain it to you. And so that's something that, for me, moving to this, the judicial branch, we don't make policy. Judges don't make law. We apply the law. And in this scenario, what I think that, folks have lost confidence in our courts is because, A, they do think that they have become a little bit political. B, they see the disparities in outcomes, and they tend to attribute that to, a lot of times, if you break it down, okay, black defendants get sent to jail more often for lengthier periods of time for very similar offenses. And so there's that inconsistency there. For me, good outcomes are making sure that people understand what's happening, why it's happening, that they get an opportunity to actually tell their stories in court, and that their stories are heard. Oftentimes when I've been sitting in court waiting for my case to be called, I can see the looks on people's faces. Do you understand all these rights that you're waiving? And they say yes. But you can see they really don't have any clue about what's happening. And to me, as a judge, it is, we have to make sure that they are understanding the rights that are being waived, that they understand what the repercussions of that waiver would be. Because if people don't understand what is happening, how do we really call that due process? The whole point is that they have a fair opportunity in court to have their day in court. And I don't see that happening if people don't really fully understand what is going on. And to me, if you're consistent in outcomes, it's not about, making an example out of somebody, or, being tough on crime or soft on crime. It's about being consistent, that people who are similarly situated get similar outcomes. And I think that when people have their ability to, tell their story in court, that they feel that they've been heard, and that all of the facts have been carefully considered in whether or not they get the outcome that they wanted, the result that they wanted. If they feel that all of those things happen, then they can at least accept the outcome. And so I don't think people want us being, oh, this person deserves to be, have the book thrown at them. It's more like, for what this person did, and based on the law, here's what would be appropriate for the results in that case.
So my response is, our legislation has a tendency to overcorrect, right? So something happens, there's a tendency, there's a lot of media press, there's a lot of pushback and it does get very politicized in terms of how people look at it. And then, boom, we have to protect the protect the community as part of the standards why we should increase cash bail. It doesn't prove any increase of appearances in court. It's already part of what the courts have been looking at when they look at the statute as it relates to bail. So a lot of times when courts look at the bail, they are looking at the need to protect the public, but they're looking at the ability of the person to appear back in court. They're looking at the facts of that particular case and that person's criminal history. So to me, we haven't. The current law was overly extended. It's not necessary. And then two, cash bail is not supposed to be used to against people of poverty. It's not supposed to be used for those who can't afford to get out. Just because someone can't afford to get out of jail doesn't mean they're going to commit a crime any more than a person who could pay the cash bail to commit a crime again. So I say that when you ask the question of what is a good example of an outcome, is when someone gets a signature bond or a low cash bond, and they come to court and they complete their court proceedings. That shows that it wasn't necessary to necessarily put someone a high cash just to punish them for being poor, because that's really what that is. And when you're setting a bail at such a high amount just to say, well, you committed a retail theft and this is your third time, and I judge and pissed at you because I'm now going to punish you and to give you this really high cash bail that I know you can't afford. I have to look at it like this. A person being removed from the community is an asset potentially, right? So when I'm looking at the factors of this person's commitment and connections to the community, do they have a job? Do they have community connections? What's their past court appearances look like? Do they come to court usually? Just because this is their third OWI doesn't mean that they don't come to court. That's the purpose of the bail. The bail is to sit there and make sure that they're coming to court, and then hopefully not gonna violate the conditions of their bond or bail. So I think that the legislation overdid it. I think that as a judge, my job would be to make sure I'm looking at the required statute. I'm taking the facts of this individual's case, and I'm applying what is reasonably going to work to get this person to complete their court proceedings. And I give a good example of that is I remember I had a hearing where I had a defendant, and the judge on her own motion increased my client's bail. And no notice, so that was another issue. And we go to court, and she increases my client's bail, and most people in Milwaukee are living paycheck to paycheck. Poverty is real in our community. And so because he couldn't go to work because he got taken custody that day, and he doesn't have the extra money to pay the bail, he was out on signature bond. He didn't go to work, so he doesn't get a paycheck. He's a sole provider for his family. Out of coincidence, the house that him and his family lived in, there was a house fire, And so now his children, 5 children, and the mother are displaced. He's in custody, and they don't have any money to pay the bail. And the problem with that is he had never missed a court hearing. This was his second charge as it relates to this, but he hadn't been found guilty yet of this crime. But when the court went back and looked at his history, he had when we did the sentencing for his actual when he pled guilty to the next case. But when they looked at it, then he ended up getting probation. So, when the court is actually doing a real full consideration of all the issues and they're actually looking at the statute as written and not necessarily just focusing on the protection of the community, you got to focus on it as a whole. You get better outcomes. You get outcomes that reflect the people that are before you. And that's what I would do as a judge.
I will say, just to add to that cash bail does not protect our communities. It just allows people who have the funds to be released and the people who don't have the funds to remain incarcerated. Our Wisconsin state statutes already have a process by which if people are considered to be extra dangerous, then they are to be detained throughout the proceedings. And when I brought that up in the legislature, prosecutors pointed out that this statute is not workable in real life. And my response to that was, then this is the statute that you should ask to be changed, not our Constitution. That's something that I don't think that the general public understands. I think they view if they're dangerous, just give them a really high bail so that they cannot be out in the community committing more crimes. But really, if you're thinking about the big drug dealers, the traffickers, they have the funds to pay whatever bond is set, so that's not really protecting our community.
And you also asked the question of how we would respond to the public scrutiny. I mean, as a GAL, it's not the public, but you deal with the scrutiny of any recommendation you make to the court. That's part of the job. If you're taking that oath, you're taking that responsibility, you understand that you're going to be scrutinized for your decisions that you make. Whether it be even sometimes the people favor. I tell people all the time, I've had cases where people will literally walk out of court, and in my opinion, but also knowing that the decision was kind of in their favor, but because they don't understand it, because they don't understand the facts of the situation, because they don't know the process or what else has gone before this court, they sometimes just don't understand that outcome. And that's happened with the media and the public, right? So a lot of times they don't understand the process. They don't know what all got presented to the court. They don't know that person's history. They don't know what information all was presented to the judge. So you have to be understanding that as long as I'm taking a consideration of the interpretation of the law, I'm looking at the facts, I'm looking at the circumstances beyond just you committed a crime, therefore you go to jail. You have to look at the case as a whole, not just one particular factor, and that's what the media typically focuses on. And then people see that one little line, that one little factor, and they run with it. And so I have to be okay with knowing that people just don't always know. And I made my decision based off a lot of other things, and that's what my job is.
Next question. I'm gonna ask one. It sounds like you've both practiced a lot in court, and so my question is, what is kind of like the most just thing you've ever seen a judge do? And I've been thinking really hard about how to ask that question. So I it can be something that didn't necessarily benefit your client, or something that you didn't necessarily agree with, but is the right outcome. I guess do you understand what I'm asking? Yeah, okay.
Well, that's a difficult question because I've always been on the defense side of things, and so if my client doesn't win, then I don't feel it's just. No, honestly, for me, I've been in front of a lot of judges who, even when they did not rule in our favor, the judges that I've appreciated in their decisions are the ones who explain it thoroughly enough so that the individual who is going to be impacted fully understands the why of the decision. I've seen, it's something that before I decided to run for Milwaukee County Circuit Court judge, I was also considering going in, applying for an immigration judge position. And I decided to go for Milwaukee County Circuit Court because Milwaukee is my home, and I want to do what's best for the people that I consider my family. But for me, in immigration court, it becomes very obvious how often folks are treated unfairly. It is an administrative court, so it's not. There's many rights that are not available there in procedure-wise, and just in general for the individuals there. And I've seen many times how judges will, because of having a huge docket, just go through the cases very quickly without people in the individuals really fully understanding what just happened. And they don't really give an explanation at the end of the proceedings. They just kind of say, we'll mail you something to tell you what happened. And so then they leave it to the lawyers to explain it to the individuals, which I don't think is really appropriate. I think that the judges have a duty to explain to the people who come before them what their ruling is and why, the basis for it. And I do understand there are time constraints, but these are human beings, and it should not be a legal factory. It should be something where people are treated with, dignity, respect, and their humanity acknowledged. And so for me, any judge that does that is doing a good job.
Well, I have experience where I don't always feel that there's a judge making a most justice decision or doing something that's showing justice. I have seen lots of times the courts utilize their role and show justice. So an example would be I've seen judges, and it wasn't my case, but I was sitting in the gallery and I was listening to the issues, and the DA was charging for, there was a car accident, I think it was an OWI, and there was some car accident and property was damaged. And the attorney was a newer attorney, probably with not as much experience. And the judge took them into chambers and explained that the DA was overcharging fees. So the judge took her knowledge of information to educate both people. She did it in chambers, but not in front of the client, so the client doesn't know necessarily that the attorney wasn't making a proper argument on behalf of her or his client, because I'm not going to say what it was. But that's, to me, a good point of justice. Taking your knowledge of something and being able to apply it to that particular case, so there was a rightful decision. And this person, who was low income, because they're represented by a public defender, but it was a contracted attorney, was able to get a right decision. Other examples I've seen is when judges have closed chambers on where it's supposed to be a public hearing, but the issues of the matter is so private and sensitive, to be respectful of the victims, be respectful of the parties, the issues before the court. They have closed chambers or kept the courtroom limited in who's involved. I've seen judges take the time just to show a little bit of compassion. I love when judges, after a trial, sit down with the attorneys, the parties, and the jury and talk about, or not the parties, but the jury and the attorneys, and talk about what went well and what didn't go well, and what they thought, and to hear the feedback of the jury. I like when judges explain in detail the rationale, as you stated, the rationale behind their decision. There's lots of good judges doing good things. And to be able to see that in Milwaukee County, and I've practiced in front of a lot of the judges in Milwaukee, there are a lot of judges who use that practice. They are showing their understanding of the people before them, and they're showing that compassion. They're not just making decisions because they understand their decision extends beyond their courtroom. And so a lot of times you can't just think, oh, I made a decision, it's affected this one person, it's done. I've seen judges address the parents on, they're taking someone to custody and they're explaining to the mom or the dad who is sitting there crying, I need you to understand why I'm making my decision, and they connect. And so that's another thing. I feel like justice is making that connection. It's being compassionate, it's being articulate, it's communicating, it's being considerate. Those are things to me that represents justice, is when people feel heard and then also listened to.
You won't necessarily have a choice as to where you go, but usually new judges go to either misdemeanor or out to children's court. Sometimes, depending on background, family court, but usually it's those two. So if you were able to take your pick, which would you prefer to go to and why? Of those two, and throw in family too.
I would pick misdemeanor court because I do have the most experience in that area. And so I would want to make sure that I'm doing a good job, and once I'm settled, then I'm happy to move to any other court. But I do have experience in children's court too, so it's more the types of cases that go there that are very heartbreaking, so that's why I would not prefer to start there. But I do acknowledge that's probably where we will end up, because that is where Judge Marshall was. So either place, I think I would do a good job, but I would be most comfortable in the misdemeanor court.
So I know there's a committee that looks at people's background, and they make the decision based on their rotation. I'm going to say this from a practicing standpoint. We have a lot of new judges already in children's court, and I'm sure that's going to be frustrating for a lot of attorneys that practice out in children's court. And I say that because if you've ever been an attorney and a judge rotates in who has no experience in or limited experience in that area of law, it can be challenging, because if the judge doesn't know and understand the law, then it makes it difficult for you to do your job as an attorney. And so right now we have a lot of new judges out in children's court. While I do have background in children's court as well as family court, misdemeanor court, I would say I would be 100% comfortable with both. But to probably give a break to the practicing attorneys out in children's, I would be okay with going to misdemeanor court as well. And I do know we place a lot of new court judges there. And then too, one of the things reason why I would be open to either, but I would go to the criminal misdemeanor, is you get to show a little bit of more discretion with bail hearings, sentencing. With children's court, there's so many more factors, there's so many more issues, there's a lot of, it depends on what area of children's court you're at, and there's more attorneys involved, and there's more factors to consider in terms of how much you can, with decisions you can make. And it's a little bit more challenging because you have families who you want to reunite them together with their families, but the family is just not doing what they need to do. And so then you get into a trial. And so then you're kind of in, like, now it's kind of out of my hands in terms of how much I can work with the families in terms of reunification, or the juvenile in terms of the criminal case. Whereas I feel like with criminal misdemeanor, maybe there just will be a little bit more connection with the litigants before me.
But I'll just have you do just a 1-minute wrap up for each of you, and Rochelle went first for the intros, so she got the first word today, so I'll have her go first now so that Marisabel gets the last word.
Okay. So the reason why the last thing I want to say is I want to leave you with a note that I am not just knowledgeable of these different areas of law and therefore able to go into various courtrooms and go in, and it helps the learning curve, but I am connected to the issues of our community. We need more judges that show empathy in different ways. I worked with a lot of pro se litigants, and the good thing about me is that when working with pro se litigants, one of the best compliments I get, and this is to this day, I have people come up to me, I have criminal cases come up to me, defendants come up to me, I've had families come up to me. I've yet to have anyone walk up to me and cuss me out, so that's a positive thing. I had so many people come up to me and was like, you made me believe in the process, or you listened, you gave me good guidance. And this is not just coming from people who I represent. I'm talking about as guardian litem or I was the opposing counsel, and I actually showed empathy. I actually showed an understanding of, you know, if this is a family law case, I get it. I'm seeing you both at your worst. I don't look at it as a personal attack. When you get mad at me or you fuss or whatever, I don't take things personal. And so I'm able to not only show empathy with people when I meet with them and talk with them, I make sure when I'm talking to them about the process, they understand it. I'll stop and give you a chance to like, okay, but did you understand this? Do you understand your next court date? Do you understand what needs to be turned in? And the last piece of it all is I would be a judge who wouldn't stop campaigning or understanding issues